All persons having business before the Honorable Associate Judges, now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Good morning. Welcome to the DC Court of Appeals. Apologies for starting a bit late this morning. We were having some technical difficulties, but I hope that we've sorted everything out. Everything is always a little bit touch and go with technology. So if anything else occurs during the argument, we will pause and take care of it and then resume. We're flexible like that. So we have 3 cases on our calendar today. I would ask that the parties, the appellant, introduce themselves for the record and let us know how much time they would like for rebuttal. I'd like to ask the parties also to remember to mute themselves when it is not their turn to speak. And with that, we will begin. And I'm hearing some noise right now, so if everyone can make sure that they're muted. So the first case on our calendar today is 19 AA 840, Richard T. Fulton versus DC Department of Employment Services. Mr. Fulton, when you are ready.
Thank you, Your Honor. If it pleases the court, my name is Richard Fulton, appearing as pro se petitioner. I respectfully request that 3 minutes of my time be reserved for rebuttal. This is an appeal from an adverse decision of the DOS claim examiner, subsequently affirmed by the Office of Administrative Hearings, in which I was denied unemployment compensation on the grounds that I had ostensibly not contributed to the pension plan of my base period employer. I ask this court to reverse on the basis that this ruling is incorrect in that it interprets DC Code Section 51107C2 in a fashion that is inconsistent with the plain meaning of that provision. That
Mr.
section
Fulton, can I
provides
ask you, Mr. Fulton, I'm sorry to interrupt. And you don't have to, when you're engaging with the court, you don't have to mute, because that's too much to remember, I think. I just had a factual question. When you accepted the lump sum payment of your contributions to this pension plan, were you advised that might have an impact on your ability to collect unemployment going forward?
I was not. I was not. Please go ahead.
And then also, my understanding from the brief, from your brief, is that accepting the lump sum payment was optional, that you opted to do it.
That's correct.
Okay.
I was not. Yep.
And what would have, this is a counterfactual, but what would have happened had you not accepted the lump sum payment?
The amount of my contribution would have been part of the corpus of the pension, and there would have been 2 things. One is the monthly payout would have been somewhat higher than it was because the corpus would have been greater. And in addition, it's my understanding that there would have been no question about my entitlement to receive unemployment compensation from DOES.
Okay. Thank you.
Thank you. So the section provides, in short, that weekly unemployment benefits shall be reduced by the prorated weekly amount of a retirement pension or annuity attributable to such week, provided, and this is the language on which the case turns, that the claimant has not made contributions to the pension or annuity. In other words, if the claimant has made contributions to his pension, he is entitled to receive unemployment compensation. So the undisputed facts, as we've just begun to discuss, are that I made contributions to the contributory pension plan until the plan was frozen by the employer in 2019. In February 2018, my position was eliminated and I took retirement, albeit I continued to seek employment elsewhere. And as we've discussed, AGC offered and I accepted their offer to pay me a lump sum representing my contributions and accruals. Subsequently, I began receiving monthly payments from the pension fund. In addition, I received payouts pursuant to a severance arrangement, and it was only after those payments concluded as of February 1, 2019, that I applied to DOES for unemployment compensation.
Can we focus on, I think we understand, perhaps my colleagues understand better than I do the facts, but can we focus on the language has not made contributions to the pension?
Sure.
Do we understand why? I mean, assume that you had never made contributions to this pension, right? It was a fully employer-funded pension. Do we understand why the legislature wanted to carve those out? Because you would agree those types of pension would be carved out.
Yes, and similarly, if the contributions had remained in the pension, then they would not have been, payment would not have been carved out. It seems to be the case that for a long time, unemployment compensation was not paid if you're receiving any other benefits. For instance, or at least would be offset by other benefits. For instance, originally, Social Security would result in a carve out. Similarly, if you were receiving money even from a contributory plan, there would have been a carve out. So over time, there has been a movement towards greater and greater willingness to allow the claimants to have the benefit of their other pension arrangements.
Right, but I mean, at least
sorry
to interrupt, but at least Social Security, in theory, we pay in and we get back what we've paid in. Query whether that will always be the case, but so I'm just trying to understand, why would the legislature carve out a wholly employer-funded pensions? What's the what's your understanding of the rationale for that?
I don't know that I have a clear understanding. I know that it also seems to be part of a federal schema as well, although one has to look to the plain meaning of what DC enacted in order to figure out what the law should be, not be dependent, especially if one is making an argument based on plain meaning. But I think there was the representative of DOS at the administrative hearing said that this was to avoid quote unquote double dipping. Now, to my mind, even where it's a non-contributory plan, an employee has in fact earned that pension. That's part of the arrangement by which it entered into employment. There might have been a greater compensation if in fact the employee was not receiving that pension, contributory or not.
Right, I saw that argument in your brief, Mr. Fulton, but that seems to be an argument against having, any carve out at all, right?
Yes, right. But I think we have to deal with the law as it's been written, and to the extent I think there's an ambiguity. To the extent there's any ambiguity, it's one that DC created by writing the statute the way it did. But I think
can I ask you a question?
There isn't really there is. Yes, please.
I just want to ask about the plain language. Strikes me as not so plain that a person who puts in a chunk of money and then takes it back has contributed to that bucket of money. I would think we'd say the opposite, that at one point in time you had contributed to that pension plan, but when we look at it now and we ask, have you contributed? The answer seems to be no, you're net zero. You took out everything you've put in, you have no contributions in that plan. Now, what's wrong with that way of reading the language plainly?
Well, the language of the law is framed in the present tense. If we just look at the language of the law, it says that the benefits shall be reduced by the prorated weekly amount of retirement pension or annuity attributable to such week, provided, and here the language shifts, provided that the claimant has not made contributions to the pension or annuity. So it shifts from the present tense to something that has been done in the past. and says nothing about whether or not
But I don't
that
know. I
contribution
mean,
has to have.
I don't want to get into the nitty gritty of the language so much, but I mean, it could have said had not made contributions to the plan, in which case it could bring in all past instances of having contributed, but it says has not made contributions. And I think in a very plain language sense, we might say that you have not made any contributions to that plan. You have made zero impact on it. You have taken out what you put in.
I just don't think that's a fair reading. I mean, if you look at the case of Inabinit, Crescent Properties v. Inabinit, where you had a party that sought to read what was written in the present tense as being also having a meaning looking back to the past, this court there said, you can't do that. You have to look at this language as it's written, which is to say it's all taking place in the present tense. So here also, they had the drafters intended to say that the question is what's going on in the present tense. They would have written something different than the language that appears in that statute.
Mr. Fulton, I want to follow up on this is Judge Long. I want to follow up on Judge Deal's question. I'm confused about a factual issue, and I'd like you to clarify it. When you sought unemployment benefits, had you started a new job after you retired from the job that is paying you a pension, or were you attempting to get unemployment benefits because the job from your one employer, your most recent one, simply had come to an end?
I did not start another job.
All right.
I have from time to time received money on for consultancy work, and in weeks in which I received that money, I did not make a claim for unemployment compensation. But I did not. I've been seeking unemployment, but I have not been able to find employment since I left that job.
Well, I thank you for that clarification. Something in the briefing gave me the impression that as a retiree, you simply shopped around for a new job, found one, that job came to an end, and that was your basis for seeking unemployment. Now you're telling me something that helps to explain the reference in the record to double dipping. Heretofore, that wasn't clear. Now it is. So why wouldn't the receipt of unemployment benefits, why would that not be double dipping?
I don't think it's double dipping any more than receipt of Social Security or receipt of a pension pursuant to a contributory plan, which is to say those are earned benefits in any event, and it's denying the unemployment compensation is, first of all, problematic in terms of the framing of the statute, and secondly problematic in terms of its becoming a disincentive to work and basically an act of, I would say, an act of injustice in terms of the way the structure is set up.
Mr. Fulton, the Department of Employment Services has never said that you're ineligible for employment benefits on this basis, correct?
I'm sorry? I didn't understand
on
the
the
question.
basis that Judge Long is I think I understand Judge Long to be asking, are you even eligible for unemployment benefits because you just retired from a job, not you retired from a job, then received another, then you were rehired and let go from your subsequent job and are now seeking unemployment. But I don't understand the Department of Employment Services to have said that you're not eligible for unemployment on that ground.
No.
The only question before us is
yeah.
how we interpret the statute about offsetting your pension from any unemployment benefit that the Department of Unemployment Services has never said that you're not entitled to. Sorry, that was a double negative.
That's correct.
That seems to have conceded that you're entitled to, and they just think that it should be offset in some way.
Yes.
Okay. I'm sorry, Judge Steele, I stepped on you. Do you have a question?
I was just coming back to a point you had made earlier, which was going back to Judge Easterly's point about these are benefits that have been earned. That's clearly at odds with the statute, though, because the statute says differently. It says even if you haven't contributed to it, even if you view it as a benefit that's earned, it counts as an offset. So no matter how sympathetic I am to the point that people earn their benefits, even those that they don't contribute to in the pension plan, that to me seems to be directly carved out by the statute, and we're not really at liberty to disagree with that policy decision.
Well, I would just say that response to that what I think the court is bound by is the plain meaning of the statute.
Sure, I mean, it all comes back to plain meaning. Yeah. I mean, I think you're in a tough spot when it comes to a policy question, and so that you have to fall back on plain meaning. And then when it comes to plain meaning, you know, I have my hangups in saying that somebody who's taken out every bit as much as they've put in has contributed to the plan, has made a contribution to that plan. I don't find that to be plainly referencing a contribution that has been withdrawn. I just don't find anything plain about that. But I mean, I take your point. It's not an outlandish reading of it.
Well, you know, if I might, Your Honor, and I know my time is running out. The equities. Let's say there was only half my contribution had remained, or $1,000 my contribution remained, or $10. So it's at some point the equities that allow somebody to receive the unemployment compensation, notwithstanding that they have only a minuscule amount in the corpus, should lead to the conclusion that where you have a statute drafted the way it is here, that we should not therefore you should therefore not rule against a claimant who had removed the contribution they had in fact made.
Thank you, Mr. Fulton. We'll give you a few minutes for rebuttal, but right now we'll hear from Ms. Browder.
Good morning, and may it please the court. Megan Browder on behalf of the Department of Employment Services. The plain text of section 51-107C2, as reinforced by the structure, purpose, and legislative history, is unambiguous. If a claimant is receiving pension payments that are 100% funded by the base period employer, those payments must offset unemployment benefits. As Mr. Fulton acknowledges, his pension payments are solely financed by his former employer. This court should therefore affirm the department's determination that he is ineligible for unemployment benefits.
So, Ms. Browder, I have a problem with saying that the plain text of the statute is clear because there are different verb tenses in the statute, and it's not entirely clear at what point of time we should be talking about, right? I mean, so the is receiving language is at the very beginning of the relevant segment of the statute, and the has not made contributions is at the very end of it. And it's not entirely clear to me how those two provisions interact. I tend to think that this is ambiguous. And then the question is the agency's interpretation a reasonable one? And one of the things that has me kind of hung up in saying that it's reasonable is the question that I asked Mr. Fulton, which is, you know, what if you hadn't taken the lump sum? He would have been getting the payments. It's not clear to me why the employer should be able to offer the lump sum and then get out from paying unemployment later. But maybe you can explain that to me.
Sure, Your Honor. Well, a couple of things. One, the department's position is that it is unambiguous, and I understand what you say about the different tenses, but I do want to link back to something that was discussed in Mr. Fulton's portion. Has not made is not the past tense, it's the present perfect tense. And we generally use present perfect to denote something that happened in the past, but continues into the present. So when you say has not made contributions to the pension, that most naturally refers to the pension that the person is receiving. And that's the common usage of the language. If someone says, I'm receiving a pension, most people would understand that to mean I'm receiving pension payments. And then the question becomes, how are those pension payments financed in the present? What do they contain? And here, there's no dispute that Mr. Fulton's pension payments are fully funded by his employer's contributions.
Don't get me wrong. I'm delighted that we're talking about the present perfect tense. It's not often that we get to delve into grammar, and that takes me back to sixth grade. But I don't know. Has not made could have a sense of like has not made to date, right? And that would be incorrect. I mean, because he has to date made contributions, he then took them out. But you know, I'm not sure that relying on grammar is the best way to get to plain meaning here.
Well, I think there in your example there, Judge Easterly, that therein lies the problem, and that you have to add words to the statute, and Mr. Fulton has to add words to the statute in order to support what he believes is the plain meaning. He says,
well, I think both parties have to add words to the statute, right? To clarify it. I think either way, that's why I think it's ambiguous.
I don't think, I mean, the interpretation that the department's giving does not add any words. It's saying has not made, which is, as we say, the present perfect tense, contributions to the pension. And the pension is referring back to something that is in the statute, is receiving, the pension that the individual is receiving. And how is that pension financed? And that's the most natural way to think about pensions and pension payments, and to pick up on something that Judge Deal said. It doesn't, in a common sense language, and you know, of course, when we're doing statutory interpretation, we want to think about what is the common and ordinary usage of words. If someone, if you gave a $50,000 donation to your favorite charity on January 1st, and on December 31st, you requested and received a refund, I don't think you would tell the IRS that you contributed $50,000 to that charity in the previous year. So in the same way, as Judge Deal says, we look at contributions as a net financial outlay. Mr. Fulton.
I just think that that's reading language. And I mean, there's the pension and then there's the pension. And are we tracing every dollar, or are we just saying he gets a pension out of this job? And yeah, you know, money has come from different sources at different times. And so it seems to me that the language, you know, your interpretation of the pension being traced to his actual contributions requires additional language. But can we move to, you know, just for the sake of argument, let's assume for the moment that it's ambiguous. I understand that you disagree. But if it is ambiguous, can you explain to me why it is a reasonable interpretation and makes sense to say, look, he can keep his money in and still get his full pension payment and not have the offset, or he can take it lump sum, you know, $60,000 up front, but then he loses the pension payment. I mean, then he loses the unemployment benefits, right? I mean, why would anyone, if they were advised ex ante, take the lump sum, right? Because that seems, you know, you're really bargaining against yourself. You would want both streams of income, right? And now you're voluntarily limiting yourself just to the payment, which does seem to be contrary to what the legislature was saying about not wanting to penalize older workers who might have pensions.
Well, a couple of things, Your Honor. I don't think that it's not as if there's no benefit to him receiving a lump sum. You get $60,000 up front. People take lump sum of severance, lump sums of different annuity streams all the time. And there is a benefit to that. Maybe he could have invested it and received more than he would have gotten for unemployment. We don't know. But that doesn't mean that he's losing out on some sort of benefit.
This pension is like a matching pension, right? So he puts in something and the employer puts in something.
That's how I understand it, yes.
Right. And so the idea that he could take the $60,000 and make something comparable or more to what he's getting through the employer's plan seems fanciful, right? I mean, I don't know. I understand time value of money, but
Well, there can be
That-
other
that-
reasons why someone would want $60,000 now than $400 on a weekly stream. Perhaps their
Well-
medical bills. I mean, there are a number of reasons why people take
Right,
I-
and the
lump sums,
reasons
and
that they
that's their
might
choice.
want it to pay medical bills might be reasons that we don't want, we don't want to penalize this person for taking the lump sum up front. Or certainly
that-
not if they weren't advised, beforehand, because you might then think, okay, I've got the medical bills, I could take the lump sum, but then I'm going to lose unemployment going forward. Maybe I should try and see if I can borrow the money instead of taking the lump sum, right? You might want to make other financial decisions if you have that flexibility.
Well, there's no indication that Mr. Fulton asked the department what would be the ramifications of taking the lump sum. We know that there are ramifications to taking a lump sum of severance, and that it gets separated out over a certain amount of time.
But
and
what
you're not-
about the point that Mr. Fulton makes that, sure, there are benefits to taking a lump sum, but under your reading, he could have taken $59,999 out of it, left $1 in, and then he gets unemployment benefits too. So all you have to do is leave a residual nominal amount in the pension, and then you're brought out from you're outside of the carve out in the statute. That doesn't make a lot of sense.
So I have
what's your- yeah.
two responses to that, Your Honor. First, we don't have the plan documents. These are things, whether you can take a lump sum withdrawal of your contributions at all and how those work is something that is determined in the plan documents.
Which I mean,
We don't
sure,
have-
the statute isn't different to it. A plan
No, I
could
understand.
say you can just contribute $1, and we advise you to do so because that's going to make you eligible for unemployment benefits, right?
I understand that. My point is in saying that the pension plan documents that I have seen, and from my understanding of pension plans, they don't allow partial withdrawals. They don't allow you to leave $1 in. If they allow you to take a withdrawal of your contributions, you have to take the whole thing. So we don't know that Mr. Fulton's absurdity would even come to pass. But even if it could happen, at least his interpretation also leads to an absurdity to say that an employer or an employee could contribute $1 and take that dollar out. And then 10 years later, when they're laid off, they're now the employer is paying them a pension and unemployment benefits. That also leads to an absurd result on the other side. So and I think we're conflating two different purposes here. We have the purpose of the overall unemployment compensation scheme, which is to protect employees and to give a minimum amount of income while they're looking for work. But then you also have the specific purpose of this offset provision, which, as this court said in Cebulski, was to prevent overcompensation and to prevent double dipping. That's the point of the offset. So whether we think it seems unfair or disadvantageous to workers, that is the legislative and policy choice that the council and before them Congress made, that if you have a pension that's paid for by your base period employer, that base period employer should not also be responsible for paying unemployment benefits.
That's my question about the double dipping point. That's why I don't understand the lump sum payment versus the waiting to get it, on a monthly basis, because it's the same money. You're just getting it up front or you're getting it monthly. I'm not sure I understand the double dipping in that context. It's not, I don't think that there's a double dipping problem. There's just a statutory language issue. And I'm just trying to understand what the point was for including, for carving out solely employer funded pensions.
So if you look, one, the issue that the council was really addressing here in 2004 was really related to Social Security, and that if someone was receiving Social Security under the former law when it was enacted in 1980, then you would be unable to receive unemployment benefits. And that didn't seem fair because Social Security, both parties pay into it, the employer and the employee. And it doesn't seem fair to penalize someone for getting a receipt of their own money back, which is the same thing here. If you have a pension that that includes your pension payment, includes money from your employer and money that you contributed, it doesn't seem fair to say that you don't get unemployment benefits when part of what you're getting back is your own individual contribution. We don't have that unfairness here. What Mr. Fulton is, he's gotten back his individual contribution. And so it's not penalizing him to say that he can't get unemployment benefits. And I think part of what is causing you pause, Judge Easterly, is that the district's offset provision is all or nothing. It's offset or it's not. In other jurisdictions, they've taken different approaches. They say that, up to 45%, or they look proportional to what the individual's contribution is, but that's not the legislative choice that was made here. Whether it was for administrative ease or another reason, the rule is if your payments are funded by your employer, then it's offset. If your payments include a return of your own individual contributions, then it's not offset. And that is under the plain language. That's the structure and the purpose, and also the legislative history. If I could turn back to the plain language part of it, the structure and the purpose also support the plain language meaning here. Unemployment benefits are on a present and ongoing basis. It's not on a retroactive basis. You can't get unemployment you can't decide I want to apply for unemployment from 2 months ago. It's from what is happening here and going forward. And so it makes sense that when you're talking about what is going to be offset against your current unemployment benefits, what would be offset is what is in your current pension payment. And here, that current pension payment is 100% employer funded. The same thing with the purpose, as we said. The purpose, as this court said in Sabluski when interpreting the 1980 version of the act, is to prevent overcompensation. Employers are taxed to pay for unemployment funds, and the more employees that they have that receive unemployment benefits, it will increase the amount that they pay. So to pay a pension and to pay unemployment benefits is unfair to the employer. And that's what we mean when referring to double dipping.
Ms. Browder, at one point in your answer, you were talking about other states' unemployment benefit schemes. And then in your brief, you mentioned the federal statute. I'm not sure how one pronounces the acronym FUTA. And I guess I'm wondering, am I correct that our unemployment benefit scheme does not align completely with the current federal statute, which I understand is it's an incentivizing taxation, structure. If the unemployment benefits schemes are not compliant, then the states have to pay money. So it nudges them to have safety nets that meet federal standards. But I take it there's nothing comparable in our statutory language in the federal statute that we could look to help us interpret or analyze this statute?
So our statute is compliant with the federal statute. All the federal statute says is that if it is a base period employer, you have to offset. But then it says it gives states the ability to take individual contributions into account. So from 1980, but they don't have to. From 1980 to 2004, DC was not taking individual contributions into account. And that is why we have the provided language in the 2004 amendment, primarily, if you look at the committee reports, primarily to address the issue of Social Security being a bar to recovering unemployment benefits. So I believe our statute is in line. If you're looking for
can I pause you right there? So what you're saying is that the federal statutory threshold for compliant benefit schemes is lower than what DC provides, because we do allow for offset for employee contributions.
That's correct. And there are about 13
I'm getting the
states
language
that don't
wrong, but you're understanding me.
I understand what you mean.
Okay.
There are about 13 states that don't take individual contributions into account at all.
Okay.
And then you have some who do like DC, where it's an all or nothing. And as I said, some who take a more proportional view of whether it's 45 or 50%. So states have done this in myriad ways. I think the closest thing, if you're looking for federal to look to, is Department of Labor guidelines and Handbook 301. It talks about, and I think this is what Ms. Robinson was looking at when she was looking during her testimony. She said the CFR, but I think she was looking for Department of Labor guidelines, which the Department of Employment Services looks to in terms of timeliness and things like that. And those guidelines say when you're looking at how things are financed and what you're going to take into account, it states if you're looking at financing of pensions, you need to establish how the pension is financed. Determine if the pension is financed in whole or part by a base period employer. So I think that is what Ms. Robinson was referring to when she was trying to look during the hearing.
Can you just point me to one of those states that implements a proportionate system that, you deduct based on whatever percentage? I assume you're talking about, if you've contributed 30% to the pension of the gross sum, then we deduct, based on 30% of that's being paid out to you, which seems to me to make a whole lot more sense than an all or nothing scheme. So I'm just curious what states are doing
Sure.
that.
Arizona is one.
Okay.
They
Is
say
is this in the brief or this is?
it's not in the brief.
Okay.
We had cut it for space, but I'm happy to.
That's okay.
get a
Arizona's
supplement
enough to work with. I was just curious.
Sure.
Judge Deal likes Arizona.
Where I'm from.
Well, then I picked the right state. So again, I don't know if Judge Ishel, if you had additional questions on deference, if I could turn to that for just a moment. We do believe that even if the court finds that the statute is ambiguous, the department's interpretation is reasonable and particularly in light of the structure and purpose and legislative history of the statute and is entitled to deference. You can look at the second amended determination, which says in particular that Mr. Fulton was denied benefits because his pension is solely financed by his employer. It does not matter that this may have been a case of first impression for the department because this court and Lincoln Hockey and Wright has looked at, has approved of other determinations from the department that came up on a case of first impression or weren't necessarily longstanding. So if there are no further questions.
I do.
Yes, Judge
I
Long.
do have a question. I want to change the focus of the discussion for a minute. There is a part of the legislation that I don't think either side has talked about it, and it got my attention, and I would like to know what you make of it. Let me tell you what that is. I noticed in the legislation that the council specifically adopted the fiscal impact statement that was a part of the committee report. This was Mr. Gandhi's fiscal impact statement, and that was required to be in the statute. And so I took a look at it. It was one of the attachments to the committee report. And in the background section, where he's explaining how he analyzed the statute, and ultimately, by the way, he found there was no deleterious impact. But when he was giving the background, he was explaining what the proposed legislation would do. And I just want to quote to you the last sentence. It says, under the proposed bill, the unemployment benefit would not be reduced by a pension amount if the individual contributed during employment to the pension or retirement plan, e.g., such as Social Security or federal retirement. That language appears to support appellant's argument that we're simply looking at whether anybody made contributions while they were employed without any reference to what became of those contributions later. What's your reaction to this and the fact that the language in this fiscal impact statement seems to be engrafted into the statute? What do you make of this?
I don't think that that changes our interpretation of it, Your Honor. If we're looking at first, there's no indication that this sort of situation was something that the council was envisioning, something where the contributions that the person made throughout their employment would not also be there when the pension started to provide payments. But I think the other parts of the legislative history, both in the DC amendment and in the legislative history of the federal statutes, it's clear that what is important and what we're looking at is what the pension contains when you're applying for unemployment benefits. So that would be my response.
Thank you.
So if there are no further questions, we would ask that the department's determination be affirmed. Thank you.
Thank you, Ms. Browder. Mr. Fulton, we will give you 2 or 3 minutes for a rebuttal. Sorry, Kevin, make it 3.
You're still on mute, Mr. Fulton.
Mr. Fulton, we can't hear you.
Yeah, I mean, I do remember that he was on mute the whole time and he was getting the audio through his phone. So it's something.
Right. Is there a way to reconnect the audio on your phone, Mr. Fulton? We're not getting anything that you're saying at the moment.
I'll give you a thumbs up if it starts coming through.
Can you hear me now?
Yes.
Okay. So a few things. One is clearly, I don't think that I'm the one that's adding words to the statute. Of course, the Supreme Court in Abercrombie and Fitch said you can't use silence to add words, and I think that that is what the respondent is doing here. But on the other hand, it's very hard to make a case that the plain language supports the respondent when so much of the case depends on legislative history, the structure and history of the legislation, et cetera, et cetera. At the very least, that seems to indicate that in order for the respondent to prevail, it would have to argue not on the basis of plain language, but on the basis of deference. I think when it comes to deference, however, as my brief, and I have to speak very briefly because the time is running short, but as my brief demonstrates, the interpretation here, even if this is a case of first impression, it's not only is not long-standing, it's not even consistent. It's not consistent in terms of what Mrs. Robinson was saying versus what the administrative law judge said versus what the claims examiner said. So it's very difficult to make the claim that you have here an interpretation of the statute that is coherent and that should indicate that there's a policy that has been adopted to which this court should defer. So it therefore falls to the court to determine which of us has a more reasonable interpretation. And I think, first of all, the Toplowski case, which has been mentioned, was a case that took place before this amendment. So,
Counsel, I just want to say, so one thing in support of their plain language argument is back at the beginning of the statute, or the relevant language, where it says for benefit years beginning on or after July 1st, 2004, benefits payable to an individual who applied for or is receiving a retirement pension or annuity. It makes it sound like the relevant point in time is not a plan that you paid into, but rather the thing that you are receiving. And perhaps you contributed to a pension plan, but you have not contributed to the pension that you are receiving. What's your response to that?
yeah, I don't think the language when it talks about is receiving is talking about whether or not that's the contributory or non-contributory plan. It's simply saying I have been receiving a pension. And then the question of how one deals with contribution that was made and then withdrawn. To understand that, you have to look at that concluding language.
Yeah, but the problem I have with the concluding language is, nobody contributes to an annuity. I mean, we don't talk in those terms. It's not an annuity until, that when you retire, you elect an annuity versus a lump sum. I think. I mean, that's how I would tend to think of it. But so when it says has not made contributions to the pension or annuity, at least I'm inclined to read that as a reference back to the first sentence, the clause that I just cited. That's the thing that you're receiving, a retirement pension or an annuity, not a plan that you otherwise might have paid into.
Yeah, I'm sorry, and I don't know why that follows. The annuity is one kind of plan, the pension is another. The fact that an annuity wouldn't be subject to this kind of return of corpus, and I don't know that that's the case, I'm just assuming, arguendo your point, that still doesn't resolve how we understand that language as it applies to a pension plan.
So what I'm saying, I think, is that people use pension in at least two ways. One is I have a pension plan, I pay into this bucket at work. That's my pension plan. Another way people use it, they say, well, I receive a pension, the check they get at the end of the day. It seems when I read the statutory language together that what it's referring to is, have you paid into the pension that you're receiving? Because that is, the phrase pension or annuity at the beginning says that you're receiving a pension or annuity. It doesn't use it in the paid into that bucket. And then later, the final language that you want to focus on asks whether or not they've made contributions to the pension or annuity, which again, I think means, have you contributed to the thing that you're then taking out? Just to read them harmoniously. And I get that you might read it differently, but I don't understand why that's contrary to the plain language still.
Well, I think it's clearly not the plain language. We disagree on that, Joe. If I might make another couple of points.
Very, very briefly, if you could.
Sure. So first, the mention has been made of the fact that somehow my receipt of the unemployment compensation would be unfair to the former employer. But AJC, my former employer, has not entered an appearance and has said it has no stake in this outcome. And moreover, should unemployment compensation be paid, the employer would be no worse off than if I had left all a part of my contribution in the fund. Indeed, to rule otherwise would result in a windfall to AJC in that it would not have to pay into the unemployment compensation program. And on top of that, there is the fact that I was advised I could withdraw the corpus, and I was not told that this would have an impact possibly on unemployment compensation. So, the fact that the issue of fairness has not been raised by the employer certainly suggests that this is not something that this court should take into account in making its determination. I've already talked about the movement towards diminution of reliance on the diminution in offsets against other forms of income after retirement. The equities that have moved on that direction based on giving employees what they earned and encouraging them to remain part of the labor market, as well as to avoid policies that resonate with age discrimination, mean to the extent there is any ambiguity in the law that DC enacted and now depends on, it should be read in the favor of the claimant, assuming there's an ambiguity that mitigates against plain meaning. So on that basis, Your Honors, I would argue that the decision below should be reversed and the case should be sent to DOS for determination of for setting the amount of unemployment compensation to which I am entitled and directing it to pay that amount to me.
Thank you, Mr. Fulton. Thank you, Ms. Browder. We appreciate both of your arguments. The case will be submitted. And now you may both log off. The next case on our calendar is 19 CV 836, James Holbrook et al. Versus the District of Columbia. I believe the parties are all here now. If If appellant would, counsel would introduce himself for the record and let us know how much time you would like for rebuttal.
Thank you. Good morning, Your Honor. Neil Henriksen on behalf of the appellants, and I'd like to reserve 3 minutes.
Whenever you're ready, Mr. Henriksen.
Thank you. May it please the court. There's no doubt that the plain language of the Whistleblower Protection Act is intended to provide broad protections for public employees in the district. And in doing so, to find this reasonable belief by the public employee, the context matters. And here, the context, like the Supreme Court has said in Harris versus Forklift, looking at Title VII cases, like this court has said, looking at the DC Human Rights Act, context matters in that the court needs to look at the entirety of the circumstance, the totality of the evidence. And in this case, the trial court had looked specifically at the acts against Officers Jones and Parker and determined that it wasn't the limited scope of acts since their 2007 lawsuit that they were complaining about regarding an administrative leave. It was a hostile work environment that included unwarranted discipline, hostility, and an abusive workplace. And that's the context in which the appellant's beliefs have to be viewed. And instead, the trial court said there were disagreements. And in that kind of look at the facts, the court judged the facts as opposed to allowing the full context to be appreciated, and that allowing a fact finder, a jury, to determine whether in fact the context provided more than a disagreement and that the appellants had each engaged in protected disclosures. So the statute really makes clear that any disclosure that is consistent with the statutory language would be a protected activity. And here we have numerous examples in this record of each of the supervisory employees having engaged in disclosures that demonstrate a reasonable belief.
Can I start you off by asking about what's your strongest case for protected disclosure with regard to Snow?
I think with regard to Snow, he had said that he believed there was mismanagement, and he had engaged in a disclosure as follows. So Snow had approved a certain personnel action that was within the scope of his duties for Jones. So he had approved that action and was on this witness list. And so, but with regard to Snow, he was, again, within this context of having personnel under him who were being retaliated against, so that the trial court recognized.
I just want to nail down your answer to make sure I understand it. I think you're
Sure.
referring to a 2010 conversation where he says he stood up and said, I would have granted this to any other employee. I don't understand why they're being treated differently, which is anywhere from 14 months to 26 months before his termination. And I don't remember, was there some intermediary before termination, some other retaliatory act that you were alleging?
For Snow, there was not, except that the principal actor was Deputy Warden Pettigrove, who was involved in each and every one of these terminations. And Lieutenant Snow was terminated the same day as Lieutenant Johnson. And so they're the nexus and connection. But yes, it is that, and the being on the witness list for Snow and the perception.
I understand that witness list
Sure.
Was created in 2007. Do we have any idea when it was disclosed to the Director Faust or anybody else up the chain?
Well, I think we go to, at least we know that in the course of the litigation, and again, this is actually, in fact, the record evidence in this is not crystal clear on that witness list, but it was certainly, and there's no dispute from the district that it did occur in the course of that litigation, which settled in the beginning of 2011, and discovery, frankly, I was involved with it, ended in early 2010 or late 2009. And so the case had that kind of life. He was on that list. And again, this act through his personnel action with regard to Jones occurred at a time frame when that action was active. And you remember in 2011, we have Holbrook saying, hey, he becomes aware because Jones and Parker come back to the jail, that upper management is concerned and wants to single out Jones and Parker. And Holbrook, I think, also provides that connection. But again, that goes back to the entirety, looking at the totality of the evidence here and each of the actors. And again, the commonality of Pettyford being this actor throughout each of the management employees, the appellants.
I'm still just trying to drill into Snow for a second. What was, and maybe this is a better question for Ms. Lebsack, what, if anything, substantiates the purported reason for his firing, that it was a mere reduction in force? Is there record evidence that, you know, X number of people were let go on that day, the decision was based on ABC, and Mr. Snow fell squarely into that bucket? You know, is there anything to substantiate it? And I'm going to ask you the same thing, and I'm going to ask her the same thing about Holbrook and Bishop, who both got the same form letter about either engaging in or attempting to engage in sexual relationships with others, identical letters with their names changed only, which makes, I want to know what substantiates that. But for Mr. Snow, was there something backing up that this was a reduction in force?
There wasn't. And then, in fact, there's evidence, record evidence at Appellate 0235 in the statement of facts about him not being eligible for rehire after this alleged riff he was told about. And so if there was a legitimate riff, he would have been eligible for rehire, which he wasn't. And there's record evidence of that fact.
Okay. So you're telling me we don't know that anybody else was let go as part of this reduction in force?
Well, we do know that Lieutenant Johnson was fired the same day by.
Well, right, that was for a cause. Their explanation was that was for insubordination. But the reduction in force, so far as we know, was simply applicable to Mr. Snow.
That's right. This unique riff, which again, there's not record evidence of, and this inability to be rehired, even though there was that activity, and there's record evidence of that inability by Lieutenant Snow to come back on board.
Okay.
So with regard to the language of the statute and the context of the reasonable belief by each that they're engaging in protected activity, again, we show unethical treatment, unlawful treatment, treatment in violation of the DC law. And again, like we've heard, like this court has said in human rights cases, in the Supreme Court has looked at Title VII, we look at this totality of the evidence, and the totality of the evidence was recognized by the trial court in denying the motions for summary judgment on Jones and Parker's claims for under the Human Rights Act and for the Whistleblower Protection Act retaliation. And that provides a context that shows that they were in fact protected disclosures by each of the appellants in their work as public employees and under the statute.
I'm sorry, Mr. Henriksen, maybe you said this already, but under the statute 1-16, 615.526, are you looking at A? What subsection are you looking at? Is this evidence of gross mismanagement? Is this?
Well, we believe it's gross mismanagement. We've pled abuse of authority, violation of law, rules, and regulations. And the whole context of this is the detention center. And so creating a dangerous environment where you have retaliatory acts against employees in a law enforcement setting that's holding dangerous felons. So it's all of those subsections that are under the protected disclosure and important rights to make sure that public employees are are protected in their reasonable belief of these violations, which they articulated in various ways. And there's no requirement, and I think the statute's plain language is clear, that they cite verse and chapter of a specific law. What they did, though, was make clear, and the record evidence is clear, that they believe there were unlawful acts taken related, or unethical acts or mismanagement is taken against Jones and Parker.
So are you relying mostly on 6D or 6A? I mean, 6D is a violation of a federal, state, or local law, rule, or regulation. Or are you talking about gross mismanagement, which has, my understanding, a pretty well circumscribed definition?
Gross mismanagement, abuse of authority, violate all of those. And as the statute says,
I guess I'm not quite understanding what the abuse of authority in connection with the administration of a public program or the execution of a public contract.
Sure.
I mean, certainly you'd have to, I think, point to a contract, first of all, if you're gonna rely on the language at the end of that provision. It would seem that you would need to point to some sort of document about a public program if you're going to rely on language earlier in that provision, or am I being too demanding here?
So I think in terms of a contract, we have record evidence about the violation of a collective bargaining agreement between the union, the FOP, and the Department of Corrections. We have in essence, a agency action.
But that's linked to the disclosures that are being made, or is that linked to the hostile work environment?
Well,
that
I think
you are alleging, and that the court seemed to think existed.
Right. Well, we're talking about the entirety of the context here. And again, looking at the earlier language in the statute about it includes disclosures made in the ordinary course of the employee's duties by an employee to a supervisor. And that's what
right,
happened.
But the disclosure has to reasonably believe, right, the employee has to reasonably believe his disclosure evidences one of these things, right?
Right, but it doesn't exactly reasonably believes in the context of treating two longtime officers, which the trial court found there were material facts in dispute about, were not being treated consistent with the rules, regulations, and policies of the Department of Corrections. So, for instance, denying medical leave, denying workers' comp claims that these appellants came across in the course of their ordinary duties as supervisors within, again, this context of a prison. And so the reasonable belief exists when you see employees being treated distinctly from other employees.
Are employees district government contractors? Right, because now I think you're talking about D.
Well, I'm talking,
right, and it's the violation of the law, rule, regulation, or term of a contract between the district government and the district government contractor. So.
Right. So we're saying all of these things provide the context, right? So, but more specifically, the gross mismanagement, the abuse of authority in connection with the administration of this program of the jails, of the law, rules, and regulations and contracts, and the specific danger to the public by having these inconsistent personnel policies in the setting. And when I say danger, it's danger to other employees, it's danger to inmates in the context of this very dangerous environment.
So there's evidence, at least, that Holbrook and Bishop thought they were reporting, standing up to illegal orders that they believed the disparate treatment was illegal. We have deposition testimony from each of them saying that expressly. I don't recall seeing any evidence that anybody thought there was a violation of a collective bargaining agreement. Is that somewhere?
In terms of I
mean, I take your point that you don't need to cite to a specific regulation or law. You know, somebody can say, look, I've been around long enough to know you don't get to discriminate against people based on sexual orientation. I can't cite you the law for that, but I'm pretty sure that was illegal, and that's why I stood up against it. I have a harder time assuming people have that intuitive notion about collective bargaining agreements and referring leave matters up the ladder rather than handling them yourself.
Well,
So unless there's testimony to that effect, I don't know if you want to put so much reliance on that.
right. I think that it's the law, rule, and regulation. I believe it was Bishop who made those statements about the collective bargaining, which all officers would be who came up through the ranks over years, as each of these appellants did, would know about collective bargaining agreements and rights because they worked day in and day out from the beginning of these lengthy careers that encompass that. But with regard to Officer Johnson, Lieutenant Johnson, she made clear she found these orders to be unethical. I'm not going to do unethical things, unlawful things related to Parker. Okay, those kind of things are a recognition that there's, again, in the broad context and looking at the totality of the evidence, that there is in fact unlawful activity going on, that there's gross mismanagement, and that they're engaging in protected disclosures. Again, plain language of the statute provides this broad protection. We're not going, outside the and interpreting anything other than extraordinarily broad protections to make sure that a reasonable belief doesn't lead to retaliation. And here we have that. And so with regard to the trial court did recognize an environment that led to the denial of summary judgment for Jones and Parker, who were the subject of these concerns that were protected disclosures by the appellants. With regard to causation, the trial court really didn't get to causation because they found in any substantial way finding these disagreements. And again, the crux of the issue here is we have disclosures that, looking at the totality of the evidence, come within the statute's protections, and that then the burden shifts to the district to show by clear and convincing evidence. And that analysis was not engaged in by the court. I'm having trouble seeing the time, and so I apologize for looking.
Your time has expired.
Thank you.
Do either of my colleagues have questions for Mr. Henriksen at this time, or?
No.
I have one concluding question, because you acknowledge that the trial court never engaged in was there an independent reason to support these terminations, whether or not the evidence was sufficient to grant summary judgment for the district on that basis. If you were to win a reversal, I take it this trial court would still be free to address that question at the summary judgment stage, right? And it should.
I think it would.
Okay.
Thank you, Mr. Henriksen. We will get you back up for rebuttal for just a few minutes, but let's hear from Ms. Lebsack right now.
Good morning, may it please the court. Sonia Lebsack for the District of Columbia. To survive the district's motion for summary judgment, the management employees needed to put forward facts from which a reasonable juror could conclude that protected activity was the real reason for their terminations. And they failed to make this showing for three reasons. They did not engage in protected conduct. Any protected conduct did not contribute to their terminations. And they were all terminated for legitimate, unrelated reasons. Each of these is independently sufficient to affirm the judgment, and I'm happy to address any of them. But the fact that the management employees failed to connect any of their alleged protected activity to their terminations is the simplest way to affirm the judgment, and it is dispositive. The management employees created no record that Director Faust had any knowledge of their alleged protected activities, but demonstrating such knowledge is essential to their clearing the bar of a prima facie case, and their failure to present such facts is fatal. If Director Faust did not know about any of this alleged protected activity, then there is no way that any of the management employees were terminated because of it.
Well, that's not true, right? If somebody, let's say Holmes or Cross, went to Director Faust and said, and they had a bad motive, and they said, I really want to get rid of Holbrook and Bishop because they're helping Jones and Parker out. But I'm going to go ahead and tell Faust that they're having relationships with subordinates. which I know will get them fired. That would be enough to support their claim, right? Even though Faust didn't know about their protection of Jones and Parker.
Well, if there were that kind of evidence in the record, this would be a very different case.
Well, I don't know. I mean, what evidence do we have about what Faust knew? This is not like the 28K letter that you cited to us recently. In that case, Mitchell, the supervisor, said he didn't know anything about it. Here, do we have anything from Faust saying, I didn't know anything about this. This is how I made my decision. Is there record evidence of that?
There isn't. What there is a 30B6 deposition and the memoranda. And in addition, the management employees have never put at issue that Director Faust was the decision maker here. And so they had to come forward with some evidence that he knew something about their protected activity. And there simply is absolutely nothing.
There's a lot, it's an incredible happenstance that Jones and Parker, whose claims are surviving summary judgment on a hostile work environment claim, it is a remarkable happenstance that 4 people, all of whom happen to help them out, all of whom happen to grant them leave and do other things to protect them contrary to orders, have been fired. That, to me, creates a pretty strong inference that Faust either knew that or he was acting on information from his direct supervisees that were depending on that. So what do you need? You need an admission from Director Faust that this is why he did it? Or is it enough that the circumstances stack up to demonstrate it seems to be a big part of the reason why he did it?
Let me take that circumstantial evidence argument head on, because I don't think there's any pattern here. In February 2012, Johnson and Snow were both terminated. The only protected conduct alleged by Snow occurred years earlier, and it involved a single leave request. So his claim essentially just fails. Then 19 months later, almost 2 years into the future, Holbrook and Bishop were terminated. And they were terminated on the same day as a group of other DOC employees who had committed sexual misconduct. And so there's simply no pattern, and these facts are all undisputed.
I'm sorry, they're undisputed? Holbrook says I didn't do any of that.
This court's precedents are clear that simply disbelieving the reason put forward by the employer is insufficient.
This is not disbelieving the reason put forward. It's saying that the factual premise of it is false. That's different. It's not, yes, I did that, but that wasn't the real reason why they fired me. That would be disbelieving the reason put forward. It is, I didn't engage in any relationship like that, and there's nothing to substantiate that I did. It's a letter, a form letter, issued to 2 people that's identical, making an allegation, stacked against a lot of circumstantial evidence to suggest that this is related to Jones and Parker.
I guess I respectfully disagree about what the memoranda show. The memoranda set out in pretty strong detail some egregious misconduct that any employer would terminate an employee for committing. And the question—
I'm sorry, tell me what when you say pretty egregious, do you mean having a sexual relationship with or attempting to have a sexual relationship with a subordinate with no other details beyond that is identical as between Holbrook and Bishop? That's the pretty egregious conduct?
That's right. The memoranda, set out the conduct for which these employees were being terminated. And I think sexual misconduct is—
Any more specifically than how I just put it?
This is the rest. So the record contains the memoranda, and it contains the 30B6 deposition where Denise Schell stated that these were the reasons for the terminations. So that is the state of our record here. But that's a compelling record. And again, the question that this court has said that we ask about this is whether here Director Faust, who is unquestionably the decision maker, honestly and reasonably believed that these were the reasons. And there's nothing in the record to suggest that those weren't, beyond the employee's own disbelief, that these were not an honest and reasonable belief by—
There is, that it never happened. There's record evidence that he didn't engage in any relationship. That, I grant you, Mr. Faust might have believed that he did, and he might have incorrectly believed that. But the fact that if it didn't happen, which there is evidence of, and at the summary judgment stage, we have to take that as being true. If it didn't happen, that's some reason to believe that Director Faust doesn't think it happened. How else do you disprove that somebody believes something about you? You say it's not true.
Right, but the employee's disbelief in the sort of underlying facts don't.
Not disbelief. I mean, he would know if he had
I think Judge Deal's point is there are no underlying facts, right? This isn't a case where there's some sort of detailed memo that says, you know, this officer is accused of having engaged in or attempted to engage in sexual misconduct with this specific employee, named by name. You know, these people corroborate that there were incidents on these days at this times that they witnessed. There's none of that. It's just an accusation, a bare accusation with nothing supporting it. So what are we supposed to make of that?
I think the memoranda here, and this involves Johnson's memoranda also, stand for the employer's rationale here. These were business judgments. They are explained in the record, and they are the reason these employees were terminated. And this court has often said that it doesn't sort of sit as a super board of employment to second guess these decisions. And so what management employees needed to do was come forward with something. And they haven't come forward.
With the happenstance that everybody who helped Jones and Parker got fired. That's a lot. And that happened for Holbrook, within a month of him saying, you know, encouraging, was it Jones or Parker to apply for a position under him, for asking for a letter to say, this isn't my decision not to give him the job. I want to do it. So I want a letter from you telling me that I can't. Within a month of that, he's fired. And then a few weeks later, I think 3 weeks later, maybe 4, Jones and Parker are put at administrative leave. That's a tremendous amount for you to keep saying there's nothing to undermine that the basis for Faust's termination, the reason why he terminated them, was for these inappropriate relationships. There's a whole lot of reason to think otherwise.
I just want to go back to the summary judgment point, right? I mean, so he, you know, the officer says, you know, I think I was terminated for, you know, in retaliation. The DOC comes forward and says, no, you committed sexual misconduct, but provides zero specifics. So how then is the officer supposed to create a disputed issue of fact at that point? I mean, he has nothing, there's nothing for him to contest other than to say it didn't happen, I didn't do it. But if no specifics are provided, I'm not sure how he can create a contested issue of fact on that point. How would he do it?
Well, certainly, I mean, there are ways, I mean, there certainly could.
Would he have to surmise, I think they're accusing me of approaching this person at this time, but let me, you know, provide my alibi and show that I was actually out sick that day? I mean, how would you create a contested issue of fact to survive summary judgment?
Certainly. I mean, I think there could be numerous ways in sort of depending on the circumstances of the case, but I think there has to be something that the employee comes forward with, because the employer has put forward a reason here. And, you know, the management employees haven't come back. I mean, the two things that they've sort of come back with are temporal proximity, and Judge Deal correctly points out that Holbrook and Bishop.
Can we just go? I mean, you said there could be numerous ways. What are the ways beyond saying I've never done anything like that before?
Well, I mean, management employees here could have deposed other individuals. They could have tried to depose Director Faust. So
you're saying it was on him to elicit more details of what the underlying accusation was so that he could then rebut it?
Right. I mean, I think they have to come forward with something. And
they being the officers.
The management employees, correct, of why essentially a reasonable fact finder, I mean, there has to be evidence from which a reasonable fact finder could conclude that the employer was lying or that they were somehow sort of mistaken about the underlying facts. And absolutely none of that happened here. What we have are, their own disbelief, to be sure. And we have an allegation of temporal proximity as to Hallbrook and Bishop only. And there, this court has said when an employer does come forward, as we have, with evidence of a legitimate non-retaliatory reason for the adverse employment action, temporal proximity is not enough. So
it's not just temporal proximity, though. It's also multiple people. It would be one thing if one person were fired and you said, well, we can't make an inference that this was an adverse action just because it happened within a month. I'm not so sure the cases support you on that, but let me just assume that we're true for a moment. How about, and it happened to another guy, same day, also a month later, just before the two people whose claims have survived summary judgment, just before they were put on administrative leave. That's not just temporal proximity. That is incredible happenstance that everybody who seems to be protecting Jones and Parker are getting fired. Seems to me a basis that a reasonable jury might think that Faust's explanation, wrote as it is bogus.
Yeah, again, I don't think there's, respectfully, any evidence to suggest that the explanation provided by the employer here is some kind of is bogus.
But there's also no evidence to suggest that it's substantiated. I mean, so I wonder why, like, what do they need? A Matlock moment where they get Director Faust to admit it, like they admit what he did? I mean, is somebody saying, I have hereby terminated you for legitimate purposes? Does that insulate them from suit unless you can get them to flip on that statement?
No, I mean, I think, the court's case law is deferential to legitimate employer reasons for doing these things. When employers come forward with reasons for why, here in unquestionably adverse actions, we're just talking about the management employees' terminations here. When they come forward and the employer comes forward and says, here, I terminated you because, and insert the legitimate reason for that termination. And I think sexual misconduct and insubordination in a prison context are unquestionably legitimate reasons. Then the employee needs to come forward with some evidence from which a reasonable fact finder could infer that something that nonetheless protected activity was the reason for here the terminations.
How about everybody who engaged in the protected activity got fired just like me, and I also never did the thing they said that I did?
Well, I don't think this court recognizes, again, that an employee's disbelief in the underlying...
You keep saying that. I understand that I don't believe the reason they're firing me is not a good enough reason to survive summary judgment. But the basis for which they're saying that I'm fired is false. And they haven't substantiated it one iota. That, to me, is very different from a mere disbelief.
Well, I guess, and I again, very respectfully, the memoranda set out the reasons.
It didn't. With who? Attempted to engage in a relationship? Did he flirt?
Well, the memoranda set out that the employees were told you're not supposed to engage with, and I think this is pretty straightforward, sexual relationships or with your subordinates. And he says, you Bishop and you Hallbrook refuse to come to order on this point, and therefore I'm terminating you because I'm not going to tolerate sexual harassment or atmosphere. I
just want to read the language. I find it remarkably opaque for you to find this so clear. He has, let's see, Captain L. Bishop, and this is the same language in both of them, engaged with the numeral 4 in the middle of it in both letters, in or attempted to engage in personal relationships with female line staff. Went out to coffee with one, touched an elbow. That's pretty short on specifics, counsel. I mean, I don't know what you can say other than I have no idea if you're Holbrook or Bishop I've got no idea what that's a reference to. And that is about as good as you're going to do in order to call that into question as a reasonable basis for the firing.
Well,
I mean,
I
what
guess-
else, other than catching Faust in a lie, other than getting him to admit it, I still haven't heard an answer of what you think would be good enough.
Well, I'm not sure that's the employer's burden. These were all at-will employees, so they could have been terminated for no reason at all. So I'm not entirely sure that there is an additional burden on the district here to provide, some sort of volume of evidence that supports the reason for the termination, when the only issue here is whether they were terminated for an impermissible reason. And here, again, they haven't even connected Director Faust with any knowledge of their protected activity. So, essentially, the record reflects that, nothing to suggest that Director Faust had any clue that, 2 years before he was terminated, Snow approved a personnel request. Or
again, unlike Kowalski and the other cases we rely upon, which there is a substantiated basis for, this is how I made the decision, this is what I knew. Here you've got nothing. So it's not like Kowalski where Mitchell says, I didn't know anything about this. And by the way, the reason I fired him is because a week before he gave me bad numbers when I had to go report to the mayor, and that's a fireable offense. That makes some sense. Here, it's a letter, and Faust never offers any explanation of what he knew and what he didn't. It looks very different from the cases you rely upon, in my mind.
Right. And again, I guess I would point to the affirmative testimony of the 30B6 deponent who identified these memoranda as the reasons. There were no other reasons. The memoranda are the reasons for the terminations of everyone except for Snow.
And then that 30B6 deponent was not Director Faust.
No.
It was, so, okay. I mean, that's a funny thing to put such heavy reliance on as to Dr. Faust's rationale.
It is what the employer's reasons are. And again, here the district didn't have to actually provide any reasons at all. And the statutory burden shifting here is not irrelevant. The management employees have to put forward a prima facie case before the burden ever even shifts to the district. And so the burden here is on management employees to put forward a prima facie case. One of the things they have to do is show knowledge. The other thing they have to do is show that their protected activity contributed to their terminations. And here, the only people who arguably sort of make the temporal proximity leap at all are Hallberg and Bishop. And again, once the district has come forward with the actual reason, the temporal proximity, sort of drops out of the equation. And so then we look at what else they raised. And all the management employees put forward, and this is the statement of undisputed material facts, was the fact that they received severance pay. And we know that that's irrelevant. That's what the Superior Court itself determined. It's what the court recently affirmed again in Kowalski. The fact that they received severance has essentially no bearing or sort of does no work in analysis of whether or not they were terminated for protected activity. So based on what the management employees actually marshaled, the facts are temporal proximity and severance pay. That's all they have. And none of those things get them over the line of a prima facie case. And moreover, there's no protected conduct here either. So, I'm happy to talk about why there's no protected conduct with respect to any of the management employees, but causation here really is determinative, and we think that the court could affirm on that basis.
Thank you, Ms. Lebsack. Do we have any other questions for counsel at this time?
No.
We appreciate your argument, and we will hear from Mr. Henriksen in rebuttal just a few minutes.
Sure, thank you, Your Honor. I want to correct I misspoke in response to Judge Deal's question. It was actually Holbrook and it's at Appendix 0220, Paragraph 5, which are the plaintiff's material facts in dispute. And it's really that Holbrook on the collective bargaining agreement, it went to the reasonable belief that he believed that Warden Harper's instructions, Deputy Warden Harper's instructions would be violative of the collective bargaining agreement. So I wanted to point that out. It wasn't the statement. Now,
I see that. Thank you.
Okay. Now, and with regard to the Director Faust, we know from testimony from Holbrook that there was a general culture among the supervisors because, and this is at the same part of the record where Holbrook is given deposition testimony about the general culture coming from Director Faust and the directors and deputy directors throughout the DOC about Jones and Parker. And in fact, counsel for the district is really isolated and disregarded the trial court's review of the evidence on Jones and Parker. Again, this entirety of the context for the evidence and looking at all circumstances and determining whether there was protected activity and a prima facie case existed. So if the court has any other questions, I'd be happy to entertain. Otherwise, we'd ask that the judgment of the trial court be reversed. And
I take it you did not attempt to depose Director Faust?
That's correct.
Okay.
Thank you, Mr. Henriksen. Thank you again, Ms. Lebsack. The case will be submitted and you may now leave the Zoom.
Thank you, Your Honor.
The last case we have on our calendar today is 19 CV 1223, Abraham Evans versus the DC Department of Employee Appeals. Counsel for Mr. Evans, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Good morning, Your Honor. May it please the court, I wish to reserve 3 minutes for rebuttal.
Thank you, Ms. Henry. Go ahead whenever you are ready.
Thank you. On behalf of Mr. Abraham Evans, Your Honor, which is the appellant herein, we're seeking reversal of the Superior Court's and the OEA's decision, which found that the MPD did not violate the 90-day rule enunciated or set forth in DC Code Section 5-1031. This case turns on the meaning on conclusion of a criminal investigation in the applicable statute. The OEA board and the trial board determined that the conclusion of the investigation in this case occurred when the U.S. attorney issued its letter of declination back on February of 2012. Our position, Your Honor, is that the conclusion of the investigation occurred well before that. In fact, it occurred when an indictment was issued for Mr. Evans on January 21st of 2011. And we say—
What authority do you have to support that understanding of the statute that an indictment would be the conclusion of an investigation?
Well, Your Honor, I'm looking—
Of a criminal investigation.
Thank you, Your Honor. I'm looking at this court's decision in Jordan, and there, this court looked at the natural meaning of the statutory language of conclusion of investigation and said that it involves action by a prosecutorial authority to either A, charge an individual with commission of a criminal offense, or B, decide that charges should not be filed. And here—
Right. And so I think Jordan, I mean, it has some helpful language, but it just seems not on point, right? I mean, Jordan was focused on something else. In that case, there was the question of whether the IG report signaled the end of criminal investigation. And we said, well, no, because they're not the prosecuting authority. They wouldn't decide when to charge or not to charge someone, right? And it seems to me, I mean, there is language about deciding not to charge, which would arguably encompass a declination letter, but I think all of that is kind of dicta, because I think Jordan is really about the who, who's making the decision, not the temporal question that we have before us in this case.
Well, Your Honor, I think, but it everything speaks to the conclusion of a criminal investigation.
Right,
And
but
I think,
would you agree with me that there's no holding in Jordan that addresses the temporal question in our case?
yes.
Jordan was about the identity of who makes the decision, not the timing issue.
Yes, Judge Easterly, I agree. It was about the identity of who makes the decision. And here we have a
And
prosecutor.
in fact, in Jordan, it said, we're not going to decide about, that they threw out arrest warrant versus actual arrest might be the conclusion of the investigation, which does signal a much earlier point in time. But that's really, I mean, we can't rely on that because they're saying we're not deciding it. I mean, expressly, they're saying we're not deciding it.
It says they're not deciding it. However, there was some guidance. And here we're
Why is that guidance if they're saying we're not deciding it? Usually when we say we're not deciding something, that doesn't provide guidance.
Well, you say you're not deciding it, but in the decision, you talked about the charge an individual commission of a criminal offense. And so I think we have to look at what happens in a specific case in order to give the natural meaning to the statute. And in this case, our position is with the indictment that was issued on January 21st, 2011, the investigation concluded in this case because the record—
I thought that there was something, sorry to interrupt you, but I thought there was something in your brief where you acknowledged that a declination letter could be the conclusion of an investigation.
Well, it could be the conclusion of an investigation, but the conclusion of the investigation in this case occurred well before the declination letter that we're speaking to. And that's what we're asking the court to zone in on, because the statutory language speaks to conclusion of an investigation. Here, on January 21st, 2011, when the indictment was issued, all the investigation was completed. All the witness statements, the surveillance tapes, the surveillance of the liquor store, all that was done. The manager of the store was interviewed. Even Mr. Evans himself was interviewed after being given his Miranda Garrity warnings. He had been interviewed. And so when the—
I'm sorry, when was Mr. Evans interviewed?
1 second here. He was interviewed back on July 28th of 2010. So he was, yes, so he was interviewed back then. And so here we are months later when the indictment was issued on January 21st, 2011. And when we look throughout the record, we have no evidence that any further investigation took place.
Oh, I don't know, Ms. Henry. What about the fact that the indictment is then dismissed? It would seem to me that would require some development in the investigation. What was the basis? I looked at the government's motion to dismiss the indictment. I don't think it gave a reason. Do you know what it was? What was underlying their decision to dismiss it?
Yes. Agent Jeffrey Williams, at some point in 2011, he took over the case. No, not the investigation, because he specifically testified at the trial board hearing that he did not conduct any further investigation. All Agent Williams did, as he testified at the trial board, is that when he took over the case, he looked at all the statements, the surveillance tape. He listened to the radio communications to get himself up to speed since he had taken over as the agent. And
sounds like investigation to me, counsel.
Right. I mean, what does investigation mean, I guess, right? Is investigation really only procuring documents and interviewing witnesses, is reading and reviewing and processing and thinking about that information, that's not investigation?
Well, in my view, it's gathering the information.
So it's just the act of
but
getting the information, but once you have it, you don't have to look at it, and reading it and thinking about it and deciding what it all means. That's not investigation.
AUSA Durham had already done that, and that's what led to the indictment. But even if we look at Agent Williams, and even if we were to construe that what he was doing in order to come up to speed with the case was part of conducting an investigation, what he testified to is that once he reviewed the case file, he contacted AUSA Durham and explained to the prosecutor that because Mr. Evans, the radio communication was showing that at times when he was going to the liquor store, he had called off for his lunch. And because MPD does not pay officers while they're on their lunch break, therefore, he could not have been accepting gratuities or at least supplementing his income at that time.
So he gives the AUSA this additional information, and they don't dismiss outright. They move to dismiss without prejudice, which seems to suggest that they want to go back and take a look at it, because they've got witnesses saying that this was happening 20 and 30 times, right? I mean, they have Mr. Evans on videotape taking an envelope of what looks to be cash, and they have witnesses saying, yeah, I did this a lot. And so it would seem that it might take a while to go back and see, did he call in for his lunch break every time that he went to pick up the cash? Is it okay just for the officer to call in for your lunch break to make this work? And so they dismiss without prejudice, which if the object of this provision is to give the officer some sort of closure and finality, getting a dismissal without prejudice seems to not give one closure, right? I mean, I'm not thinking I'm free and clear if I get a dismissal without prejudice. I'm thinking I'm still in jeopardy of them coming back against me with new charges.
Well, Your Honor, if I may at least embellish a bit on the facts. When Agent Williams spoke with AUSA Durham then conferred with MPD's general counsel on that issue. And
is this in the record?
Yes, Your Honor.
Okay.
Yes. And
where are you looking?
It's at pages 87 to 88 of the appendix, and that's from Agent Williams's testimony before the trial board. So the AUSA conferred with the MPD's general counsel, and through that collaborative effort, Your Honor, that's when the decision was made to file a motion to dismiss the charges. And I appreciate
but this is all coming out at the trial board, which is in June of 2012, and I think what I understood your argument to be, which is, look, my client thinks that he is safe once there's a dismissal without prejudice in December. And obviously he doesn't know that the general counsel has been conferred. And what he knows is that he's interviewed again in February by the IAD, right?
Your Honor,
before the declination letter is issued.
But something more significant occurred before that, Your Honor, this quote unquote re-interview. Most significantly is the fact that on January 4th of 2012, the Metropolitan Police Department removed Mr. Evans from indefinite leave, restored him to full duties, brought him back to work. And if that is not clear-cut concession by the Metropolitan Police Department, that the criminal.
Well, let me respond to that. But first, I want to make sure I correct my facts. I was mistaken. He's interviewed after the declination letter is issued.
Yeah.
But I think this is where Jordan cuts against you, right? Because Jordan is saying, look, the employer, the agency is one authority, and they're not in charge of the criminal investigation. And so them issuing a report is not a signal that the investigation is over, right? And so arguably him being brought back to work is not a signal that the criminal investigation is over, right? The prosecuting authority, which dismissed without prejudice, still hasn't said anything, right? And so, and they don't say anything until February 17th. And so that seems to be the sign. And one thing that I didn't see you address, but is discussed by the MPD is that, or in the Office of the Attorney General's brief, is this MOU between the MPD and the U.S. Attorney's Office. Because it seems to me that the MOU is pretty important. The MOU explains, right, there are two interests happening in this statute. They're being protected in this statute. On the one hand, the council wants these, FEMS officers and MPD officers to have some sort of closure, to have these disciplinary proceedings brought in a timely fashion, right? And so there's this 90-day provision, right? But on the other hand, the council said very clearly, look, we don't want to create a loophole for, getting away with misconduct. And so we want to allow time for criminal investigations. And so we have this tolling provision that while a criminal investigation is going on, the 90-day period for the discipline doesn't start, right? And you can understand why that's true, right? We don't want these agencies stepping on on each other's toes, right? We don't want the employer to be mucking up the criminal investigation. The employee might have some Fifth Amendment privileges that need to be preserved, right? And that's what the MOU really gets into detail about, right? And talks about making sure that these agencies are communicating with each other, and that there won't be any compelled interview of the employee while the criminal investigation is ongoing. And then it talks about the MPD being able to ask for a declination letter, essentially so that they know that the baton has been passed, right? They need closure, right? And so they can ask for a declination letter, and they're entitled to it within 3 business days under the memorandum of agreement. And this memorandum of agreement predates the current statute, but it's referenced in the legislative history. And so it makes it sound like the council knew about these declination letters and knew that this was a way to understand when a criminal investigation was over, right? By getting a declination letter. What is your response to that? Because I didn't see any discussion of the MOU at all in your brief or in your reply.
Your Honor, I appreciate all those policy considerations. However, when we look at the facts of this—
Well, it's not a policy consideration. I think it's part of the legislative history. And if we think that conclusion of an investigation is ambiguous, then we can look to the legislative history to understand what that meant. And I think that this is part of what was in the background of the council's thinking when it said conclusion, or arguably was when it put conclusion of the investigation in the language.
And with that, Your Honor, as being part of the council's thinking, the memorandum of understanding, here in this case, there was no opportunity or anything that the MPD was going to be stepping on the toes of the prosecutor, because the prosecutor had determined from the dismissal that because based on the conference with the general counsel, that they could not legally move forward with the prosecution, and that's why they moved for dismissal. So there was no expectation that they were going to come back. There was no Fifth Amendment privilege issue to be served
Well,
here.
how can you
because-
say that if it's a dismissal without prejudice, right? We don't know, and presumably that is why MPD reached out. I mean, you made a point of emphasizing that the declination letter itself references an earlier email conversation, right? And you seemed to think that that was significant and adverse to the MPD, but it seems that that was just a reference to the request for the declination letter as is contemplated under the memorandum of agreement, right? The MPD is entitled to ask for the declination letter, and the USAO has to give it to them within 3 days. And so the declination letter says, per our earlier email, here's my declination letter. And that's when, granted, the record is a little bit messy because, I mean, this comes from the OEA ALJ. The OEA ALJ represents that IAD opens up its investigation, reopens its investigation into Mr. Evans on February 12th, and the declination letter doesn't come until the 17th. And that's a question that I'm going to have for Mr. Phillips, is whether or not the OEA ALJ was correct. I'm not sure that I saw that in the briefs, that anybody is adopting that understanding of the timeline. But if we set that aside, and the next thing that happens after the dismissal without prejudice is the February 17th letter of declination, then it really does seem like MPD is waiting for the U.S. Attorney's Office. Like, well, what are you going to do? We'll give you a little time to kind of think about this. You've dismissed without prejudice, and now we're going to contact you and ask you for the declination letter because we want to move forward. We think that this person needs to be subject to internal discipline. What?
Your Honor, I appreciate those comments. However, I read the declination letter differently because it says, this letter will confirm our email indicating declination of criminal prosecution. So the our I take to mean AUSA Durham and everyone on his side from the prosecuting office, that they sent an email indicating declination of criminal prosecution. Or otherwise, it would have been, this is in response to your request for a letter of declination or words to that effect. So in our view, there was an email declining prosecution.
Maybe so, but the memorandum of agreement says you have to provide us with an actual letter. Like, an email is not going to do. And so maybe MPD reached out and said, what's the deal? What's the status? And, the U.S. attorney wrote back and said in an email, we're going to decline. And the MPD said, great, we need the declination letter per the memorandum of agreement, right? I mean, we don't know exactly what happened, but what we do know is that the declination letter seems to have come and seems to have been contemplated by this memorandum of agreement that, was created almost 20 years ago and still seems to be in effect.
But Your Honor, this memorandum of understanding seems to have been contemplates the declination letter in those circumstances where there's nothing happening between. There's this investigation and we don't know what's happening. We don't know what's happening. Are you going to charge? You're not charging. If you're not charging, then please send us a letter of declination. That is a starkly different situation than circumstances where you have an indictment, as in this case, which is a very bright line signal of the conclusion of the investigation. And Your Honor, if that is not the conclusion of the investigation, then as we argued in the brief, alternatively, there are several other points along the way, including the dismissal in November of 2011, and then bringing back Mr. Evans to work in January of 2012. And no matter where you put that triggering event along that continuum up to January of 2012, the 90-day period expired, and this termination is in violation of DC Code Section 5-1031. And so we would
Very
ask
discreet question.
for reversal.
Because they're so close to the 90 days underneath their own theory, do we know anything? Did you request to know what date the email was sent prior to the declination letter? I take it the record's just silent on by how many days that email preceded the letter.
Yes, Your Honor. I haven't seen anything in the record to tell us that date, but I would suggest.
If it were just 2 days earlier, they'd be out of time under their own.
Yes.
Right?
Yes, Your Honor. And I would suggest to this court that if that email supported the Metropolitan Police Department, it would have made it into the record somehow, and therefore the inference should be adverse to the district on that point. Thank you.
Thank you, Ms. Henry. We'll hear from Mr. Phillips, and then we'll hear again from you.
Good morning, and may it please the court. Graham Phillips on behalf of the Metropolitan Police Department. I'd like to start by highlighting an important principle that I hope the court will keep in mind as it decides this case, namely that Section 5-1031 should be interpreted so that it's actually workable and administrable by MPD. MPD needs to be able to determine in real time, prospectively, when the 90-day clock has started to run. That means that as much as possible, MPD should be able to rely on formal actions and bright line rules to determine when a criminal investigation has concluded.
So why couldn't the voting of an indictment be a bright line or a dismissal without prejudice?
Well, Your Honor, an indictment certainly is a bright line of something, but it's not a bright line of the conclusion of a criminal investigation. No prosecutorial entity secures an indictment and then stops investigating. Not only do they not do that, really they can't do that because of the nature of what constitutes a criminal investigation. And I think some of your questions in the top half of the argument get to that.
And yet there are some limits, right? I mean, you can't keep bringing witnesses in front of a grand jury after you've indicted. I mean, there are concerns about, abuse of prosecutorial power once you've actually decided to indict.
It's correct, Your Honor, that there are certain investigatory tools that come off the table once you've indicted someone, but I don't think that means that the investigation stops. I mean, I think any case, however it turns out, is going to involve further analysis and development of the facts by the prosecutors and their investigatory colleagues. And all of that constitutes part of the criminal investigation. So I think
let's talk about the alternative dismissal of the indictment then.
Sure. There would certainly be a very strong argument that a dismissal with prejudice is the conclusion of a criminal investigation. But obviously, in this case, the dismissal was without prejudice.
Is the declination letter with prejudice?
No, the declination, I mean, I don't think the notion of prejudice strictly applies to a declination letter.
Nothing stops you from re-upping that investigation after issuing a declination letter. I don't mean you, the U.S. Attorney's Office, from re-upping an investigation after issuing a declination letter, right?
I don't think anything legally prevents it. I'm not aware of it ever happening.
It seems to me to be very much on the same footing as a dismissal without prejudice. But I suppose if we stray from bright lines for a second, can you point me to an iota of investigation that occurred in this case between dismissal of the indictment and issuance of the declination letter?
So I think the declination letter itself is the evidence of the investigation insofar as it indicates, it reveals that the prosecution continued to consider.
It's a surprise to me. What if it had been a year? And what if the U.S. Attorney said, we bungled this. We meant to issue you this letter a year ago because that's what a memorandum of understanding is. We just forgot. So we'll issue it today. I appreciate the need for a bright line, but I do wonder who ought to suffer from that type of inattention to detail, whether or not it's the individual that the statute of limitations is meant to protect, or whether or not, MPD has a little more power to say, hey, USAs, you're really messing with us here by not issuing these in a timely way. This case, for all we know, they just forgot to issue it for 3 months, right? There's nothing in the record to suggest otherwise.
Well, there's nothing clear in the record. And I'd like to return to that point because I think that's an important part about the procedural history of this case. But this court in Jordan did leave open the possibility in footnote 5 at the end of the case that a sort of prolonged period of inactivity could perhaps signal that, in fact, the investigation had concluded. Though I'll note that the timeline at issue in Jordan, where this court said that period of inactivity, which was, I think, sort of from mid-May to mid-July, it said that that was not a problem, and that's quite similar to the timeline we're talking about here. So I think you can leave open extreme cases, and I think you can leave open if there's actual evidence that a declination letter is some kind of pretextual maneuver to try to save the 90-day deadline for.
I mean, that makes it sound so nefarious. I don't mean it to be nefarious. I just mean fell off of somebody's radar. And in all fairness to MPD, I'm with you. You ought to have a very clear signal that this investigation has wrapped up. My only question is, what happens if the AUSA drops the ball on that? And then waits a few months, 3 months in this case, could be a year. It says, oops, forgot to issue this letter. Here you go. Is that, so what? Is that what we say to that? Do we say for the 90 days, the statutory system can be overridden quite easily with a simple form letter?
Well, a couple of things. Again, I don't think you need to sort of resolve cases of extreme delay and leave open the possibility of extreme circumstances. But I do think the better reading of the statute and the better interpretation is to focus on this type of sort of clear rules. Because again, I think from MPD's perspective, MPD needs to sort of be able to judge this in the moment prospectively so that it's not faced with situations where suddenly it discovers, based on facts outside of its control. And here I think it's important to note that we're not only talking about criminal investigations by the U.S. Attorney's Office, where MPD and that office have a sort of relatively close relationship and might have sort of better understandings. But we're talking about all criminal investigations by any law enforcement entity anywhere in the United States. I think we want to, it's really going to be unworkable if MPD can find itself in the position where, based on facts that it didn't know, it's suddenly revealed that actually the clock has already been running for 30, 60, or 100 days. So I do think, especially in the sort of mine run case, and I don't think there's anything that suggests there's something odd or untoward that occurred in this case, focusing on the declination letter itself is really the key to making this statute workable in practice.
So, but that comment then gives me a little bit of pause, because I was thinking there's the MOU, and so the USAO has this practice of issuing declination letters. I mean, to my knowledge, declination letters are not sort of the usual result of the end of a criminal investigation. It's not, I wasn't aware that that's how all criminal investigations ended, with declination letters if charges aren't pursued. But it seemed to me that at least in the district, as between the MPD and the USAO, they have this established practice of issuing declination letters if they're not going to go forward with criminal charges. But if we bring in, prosecutorial entities from other jurisdictions, how do they know to issue a declination letter? And how does that work really?
So a couple points. One thing I wanted to bring up about the memorandum of understanding. It does give rise to this practice of declination letters between the U.S. Attorney's Office and MPD. And I should note that in fact, the same practice occurs between OAGs, criminal prosecutors, and MPD. But one factual point I wanted to note, Judge Easterly, is that the memorandum is not currently in effect. It came to an end in 2008, but it was the backdrop against which the statute was passed.
I apologize to interrupt you there because, I think you gave us a link and the document that's linked online, I believe, says that it's current as of 2015 or something. And am I confused?
Your Honor, I think I see what you're talking about. I fear that that's sort of just the DOJ sort of website saying the last time they've updated this web page. I didn't mean for that to represent the current status of that memorandum.
Well, I'm glad I asked. Thank you.
But I do think the memorandum, I think, is quite informative because it is the backdrop against which this statute was passed. And as you noted, the legislative history specifically references it, and this practice has grown out of it. So
just to clarify, the agreement itself is defunct, but the practice itself, your argument is it informed the legislation and it continues de facto today.
That's right. I don't mean to represent that all aspects of the memorandum are operating today, but the practice of issuing declination letters when a case has been referred to the U.S. Attorney's Office and they ultimately decide not to pursue criminal charges, that practice.
But I suppose that's not really anywhere in the record.
No, it's not, Your Honor. And maybe that might give me an opportunity to return to a point I mentioned in response to one of Judge Deal's questions, which is about the record here. I think it's important to note that this whole issue of compliance with Section 5, 1031 was not raised at the MPD trial board hearings. And I think that's very important because that is the trial, that's the trial and the fact-finding stage of this type of proceeding. And so I think in this case, the record does, frankly, as a matter of fortuity, provide all the information you need to resolve this case. But the issue was not raised.
I'm sorry to interrupt you there, Mr. Phillips, but it seems to me that you could read this provision as almost jurisdictional, right? In which case, would the onus be on Mr. Evans to bring it up before the trial board? Wouldn't it be timely if he brought it up before the OEA appeals board, who seems to think that this was I think they called it mandatory, this timing provision. And then also Mr. Evans brings up the fact that the MPD did not raise this issue before the Superior Court. And granted, we're not reviewing Superior Court's order, we're really reviewing the substance of the OEA appeals order, but it seems to me that at least for exhaustion purposes, it has to be brought up before the Superior Court for us to review this argument that Mr. Evans waived this possibly jurisdictional impediment below. Did that
Sure. Let me try to. It did, Your Honor. Let me try to sort of tackle both halves of it. On the question of its jurisdictionality, I think there's no support for the notion that it's jurisdictional, and I think this court's recent cases have rightly taken a strict stance towards whether statutory deadlines and other claims processing rules are jurisdictional, and it says they are not unless they speak clearly in jurisdictional terms. And so I think this court's Baldwin case, it's from 2020. Is about, it's an OEA case. It's not about Section 5, 1031, of course, but I think it's very informative about this court's standard for whether a statutory deadline is jurisdictional. And it quite clearly says that the fact that a statutory deadline is mandatory and speaks in mandatory terms does not make it jurisdictional. So I think it's quite clear that 5, 1031 is not jurisdictional. And is an affirmative defense that's waived if not raised. Let me take your point about the Superior Court proceedings, and I agree that we did not argue this non-preservation point in our Superior Court brief, but I think there's sort of two reasons why that's not a problem. One of which you alluded to, which is that this court is reviewing the OEA's decision, and I think you sort of pair that with the fact that. We're not the ones attacking the OEA decision. I think it would be very problematic if we were trying to attack the OEA decision on a new argument that we didn't raise in the Superior Court. But we're simply pointing to an alternative ground to affirm the OEA's decision. And we absolutely did make this preservation point at both stages of the OEA proceedings. Now, the OEA board did not address it because it agreed with us on the merits, and this court can do the same. And quite frankly, MPD would prefer that this court resolve the merits of the Section 5 1031 issue. But I do think if this court disagreed, it would remand to the OEA. And I think the OEA would have to address our preservation argument because we made it before the OEA. And our point is that I think there's only one answer it could permissibly reach.
Because so much of your appeal is to a workable standard, can I ask, has there ever been another instance where there was both a dismissed indictment, a subsequent declination letter, and the charges were commenced within the 90 days of the declination letter, but not the dismissed indictment?
I'm not aware of one, Your Honor. I
know that's a very specific fact pattern. I just wonder, the basic question is what's unworkable about using dismissal of an indictment as an equally clear line that is equally administrable?
Well, I think the problem with it isn't a lack of clarity. I mean, there are lots of rules one can imagine that would be perfectly clear. All criminal investigations end on the next January 1st.
You just think investigations might still be ongoing after?
Exactly. Yes, Your Honor. Yes. I mean, and I also think it's important that it's quite common for, or I'm not sure I could say quite common, but it is not unusual for prosecutors to dismiss cases without prejudice and then to rebring them. In part, one of the reasons they sometimes do that is precisely to continue the investigation further. We cite 5 or 6 cases in our brief that sort of speak to this point. So I think what you suggested in one of your questions, Judge, usually about is it reasonable for someone to think that a dismissal without prejudice is the end of the line? I think that's not a reasonable objection in the moment, and it's just factually not true here. And the declination letter is the evidence and is sufficient evidence that it was not true in this case. I think it would be true even if the letter just said, we're declining further prosecution of the particular charges that had been indicted. But as we note, the letter also references additional criminal charges that had not been part of the original indictment, which I think is just further evidence that there was continued consideration of other charges, which entails further analysis of the facts, and that is part of the criminal investigation.
I have a final question for you, and I'm going to pose the same question to Ms. Henry, which is, what's the rule that you want us to adopt? Or I guess maybe, I mean, you did say that the MPD would like us to reach the merits. Maybe you still want us to have a very case-specific holding, but I'm curious to know if you could articulate a rule that you would like us to adopt in interpreting this statutory language.
Well, I think we would like you to reject quite firmly the notion that the filing of criminal charges marks the conclusion of an investigation, because we think that position is just wrong as a matter of law and will be wrong across the board. And to reject as well the notion that the dismissal without prejudice is necessarily the conclusion of an investigation. I hesitate to say, I don't think you can always say that a declination letter will always be the end of a criminal investigation. I would love to give you a rule as categorical as that, but I don't honestly think I can do so. But I think a letter of declination, if there are no other circumstances, should be treated as the end of a criminal investigation.
Thank you.
If I might just very quickly, I just wanted to touch on the suspension point very quickly, which is I don't think you can treat the suspension as being any sort of indicator about the existence or not of a criminal investigation. And I think the clearest indication of that is that everyone agrees that Mr. Evans was under criminal investigation from early 2009 to at least until early 2011. And he was not suspended during that time. The suspension was simply aligned chronologically with the period in which he was actually under indictment. It was the indictment that caused MPD to suspend him, and it was the dismissal that led them to remove the suspension. But it isn't the case, and it's not reasonable to think that whether an officer is suspended or not is a signal of whether he's under criminal investigation or not. And finally, Judge Easterly, I just wanted to touch on one factual point you raised, and just to try to make it as clear as possible about this confusion between when this interview of Mr. Evans occurred in February 2012. There is some confusion because there's a typo in part of the record saying that this interview occurred on February 12th, 2012. That's not correct. It occurred on February 22nd, 2012.
Oh, and so thank you for clarifying. So that's why the OEA ALJ gives the February 12th date as the date the IAD reopens its investigation.
Yes, Your Honor. That's why.
I
But if you look at there's an actual transcript of that interview. It's very clearly that it's on February 22nd, and it's elsewhere in his investigative report that it was February 22nd. And frankly, that's what makes sense. I mean, the whole point here is that interview was part of the disciplinary investigation, and MPD resumed the disciplinary investigation after they received the letter of declination from the U.S. Attorney's Office.
Thank you. Thank you for clarifying that.
I'm happy to answer any further questions, but if not, we would ask that the court affirm. Thank you.
Thank you, Mr. Phillips. Ms. Henry, we'll hear from you again.
Yes, thank you very much. As to the issue of waiver, there's absolutely no waiver here because even the Office of Employee Appeals has ruled, as you, Judge Easterly, mentioned, that these types, the 90-day rule, the 55-day rule, they are essentially equivalent to a lack of jurisdiction claim, which of course can be raised at any time. And this language comes from the Curtis Adamson case, which is a 2008 case from the Office of Employee Appeals. And if it can be raised at any time, it could even be raised for the first time before this court. But at any rate, there was, even if waiver is an issue, which it's not really, but even if it were, there was no waiver because at the beginning of the trial board hearing, Mr. Evans's attorney raised the 90-day rule, saying it was a violation and the hearing would not proceed, but the trial board decided to proceed. The problem that we have here is that that was not in the transcript because it was done at the beginning of the hearing. However, we have in the record at supplemental appendix submitted by the MPD, page 15, which is the brief that employees submitted to the OEA. And in that brief, it makes reference to the fact that
I'm sorry, page 15?
Yes.
15, got it.
Yes, it makes reference, Ms. Rucker, who represented Mr. Evans at that time, makes reference to the fact that she did raise the 90-day rule at the beginning of the proceedings. And Mr. Kevin Turner, who represented the MPD, he was also the person representing the MPD at the trial board. And in his responsive brief, he did not contradict in any way that. All he did is, as MPD is doing before this court, is to say that was not in the transcript itself of the proceedings. But that issue was raised, not waived, and it could not be waived because it's a mandatory requirement which the MPD violated, and hence the termination or the advance notice was issued in violation of the statute. I want to address, Judge Easterly, your question about what's the rule we want you to adopt. Well, the rule I want you to adopt is that this decision of what's the conclusion of a criminal investigation is a fact-specific determination based on the circumstances of a case, because we've seen across cases that in some cases you have an investigation, there's no indictment or arrest, and then you have a letter of declination. In those circumstances, the letter of declination will become the triggering event. But there are other circumstances, as here with Mr. Evans, that you have an indictment. And this indictment came after a comprehensive investigation. So
I guess, Miss Henry, how would, I understand, I think what you just said is the rule that you would have us adopt is that we should look at the totality of the circumstances.
yes,
But
yes.
how does that serve either your client or the MPD, right? Both of whom have an interest in some bright lines here, right? Because my understanding is that your client wants some closure, right? He wants to know when he's safe. And the MPD wants to know when the prosecuting authority is done so that they can do whatever they need to do, they feel they need to do from an internal discipline standpoint.
Yes, Your Honor.
And a sort of ex post totality of the circumstances by a court doesn't seem to protect either of those interests.
But we can go back to the conclusion of an investigation. And when I say fact specific, you look at the facts. And in this particular case, when you do look at the totality of the circumstances and the specific facts, with the issuance of the indictment, that concluded the investigation. There's nothing else in terms of an investigation that was done. All the statements were taken, the surveillance tapes were obtained, the radio communication were obtained, and all of that, or some of that, was what the AUSA Durham presented to the grand jury, and an indictment was issued. The record here shows that there was no other witness was interviewed, no other surveillance was conducted, nothing else was done. The only thing that was done after that was a new agent came on the case and pointed out the legal infirmity of the charge because Officer Evans was on his lunch break at the time, was not being paid by MPD, and thus could not have been supplemented his income for purposes of the charge. So there's nothing else that was done. And if Mr. Evans cannot depend, count on...
That sort of sounds like a break in the investigation to me, counsel. It's like somebody pieced some things together, and that's why the indictment got dismissed. You know, so some post-indictment, they pieced together that the times lined up with a lunch break that he wasn't paid for. I mean, it sounds like a continuation of the investigation to me.
But Judge Deal, even if that were the continuation of the investigation, it certainly concluded with the dismissal. Everyone agreed that the charges were infirm, that they couldn't go forward, they were legally infirm, and that concluded the investigation. We just look at MPD's own actions because they brought him back to work. This reopening of an investigation, so to speak, with a re-interview of Mr. Evans on February 22nd, 2012, was really a pretext to try to extend the 90-day rule because MPD learned nothing new. They asked him the same questions they did back in 2010. He gave the same answers, so they got the same information, learned nothing new, and therefore all the charges that underlie the advance notice of proposed termination, they were submitted after the expiration of the 90-day period, and thus the termination should be invalidated. The Superior Court's decision, the OEA decision should be reversed. And I thank you for your time.
Thank you very much, Ms. Henry, for your argument. Thank you, Mr. Phillips. This case will be submitted and we stand adjourned. Council can leave the Zoom.
Thank you.
This honorable court